This video is brought to you by C&M Homes Incorporated, the manufactured housing professionals, specializing in complete turnkey packages and serving you for nearly 20 years. Located at 3603 North M30 in Sanford, they can be reached at 989-687-9461.
Session. Yeah, well, Commissar presiding.
Good morning, good afternoon, you may be seated. Calling the cases of People versus Charles Howard Rowan, file numbers 13-6920-FC and 13-6921-FH. Would counsel identify for the record, please?
Aaron, we're hearing on behalf of people.
And please, the court, Scott Parker, the defense.
And sir, would you please raise your right hand to be sworn?
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Could you tell us your name?
Charles Howard Rowan.
And Mr. Rowan and Mr. Moore, would you please come on up to the lectern? And proceeding in file 13-6920-FC, Mr. Rowan, have you received a copy of the information in that file charging you with count 2, the life offense felony commonly known as armed robbery?
Yes, sir.
Do you wish to have a reading of that information?
No, sir.
Do you wish to have a preliminary examination?
No, sir.
Now, sir, do you understand that according to count 2, you are being charged with the crime that is commonly known as armed robbery?
I do, sir.
Now, that crime is a felony, and it carries a maximum penalty of life in prison or any term of years in prison. Do you understand that?
I do, sir.
The minimum sentence would be discretionary with the court unless there was an aggravated assault or a serious injury involved, in which case the minimum end of the sentence could not be less than 2 years in the state's prison. Do you understand that?
I do, sir.
Now, there is one of 3 possible pleas that you may make to count 2, armed robbery. You may plead guilty if you are guilty, but don't plead guilty unless you are. You may plead not guilty, or you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the one of 3 possible pleas that you may make to count 2, armed robbery?
I do, sir.
Then answering to the charge of count 2, armed robbery, what is your plea?
Plead guilty.
Now, do you understand that no one can make any promises for me about what your sentence will be?
Sir.
The court also informs you that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore will be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge without a jury, if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all the witnesses against you appear in court, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you may want for your defense to appear in court, the right to remain silent and to not have your silence used against you, but finally you also have the right to testify at the trial on your own behalf, and if you choose to testify, then your testimony will be considered in the same manner as the testimony of any other witness. Now, do you understand all those rights?
I do, sir.
And do you understand that by pleading guilty to count 2, armed robbery, that you'll be giving up each and every one of those rights in both of these 2 files?
Yes, sir.
Now, I'm going to ask the elected prosecuting attorney, Mr. Miller, and your attorney, Mr. Scott Moore, to tell us what the plea agreement is. And I want you to listen to them very carefully. Mr. Miller, what is the plea agreement?
Your Honor, Mr. Rowan has pleaded guilty to count 2 armed robbery. There is an agreement under Briggs and Kellerud that the sentence as to initial incarceration to be within guidelines, specifically Grid A, Rowan column E3. Mr. Rowan must cooperate and testify against any co-defendants and in all matters arising out of this incident. Mr. Rowan is also to make full and complete restitution as in an amount as determined by the probation department. In exchange, people agreed not to seek an enhanced sentence as a habitual offender. People also dismissed the remaining counts in both files, and in addition, a district court file 13-16-76 FY.
So among the other terms that you set forth, in addition, as you explained, the minimum end of the sentence will not exceed the amount recommended under the applicable sentencing guideline range.
Correct, Your Honor.
Mr. Moore, is that your full and complete understanding of the plea agreement in this matter?
Yes, Your Honor.
Mr. Rowan, did you hear what your lawyer, Mr. Moore, and the prosecuting attorney, Mr. Miller, said the plea agreement is?
I do, sir.
Did you understand the plea agreement?
I do, sir.
Are you in agreement with that plea agreement?
Yes, sir.
Has anyone promised you anything beyond what is in the plea agreement to get you to plead guilty to count 2 armed robbery? Could you speak up a
No,
little?
sir.
For example, has anyone promised you that if you pled guilty to count 2, that this court would be lenient or light on you in any way?
Yes, sir.
Has anyone threatened you or your family to get you to plead guilty?
Yes, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
I do, sir.
Do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
I have, sir.
Now, in light of everything that the court has told you, do you still want to plead guilty to count 2 armed robbery?
I do, sir.
Very well then, drawing your attention back to March 18 of 2013, were you in Sage Township in Gladwin County, Michigan?
I was, sir.
On that date and at that location, did you go to a gun store located, I believe, on Chapel Dam Road?
I did, sir.
And did you go there in the company of any other people?
I did, sir.
Who did you go to the store with?
Rosamond Martinez.
And did the 3 of you drive over there together?
I did, sir.
Who drove the car to the store? And then when you arrived at the store, before you arrived at the store, had there been any kind of discussion between the 3 of you, Mr. Bowman, and Ms. Martinez, about what would happen at the store?
Yes, sir.
And was there a course of action that was agreed on that would happen at the store?
Yes, sir.
And what was that agreement?
I was to take guns from the owner.
And was there any discussion about how you would take these guns from the owner of the store?
Yes, sir.
And what was the nature of that discussion?
I was supposed to use mace,
Mace being like
pepper spray.
a pepper spray? And that was an item you would use as a weapon to either spray the owner of the store or at least to scare him into complying by threatening to spray.
Yes, sir.
And Did Ms. Martinez agree to that course of action?
She did, sir.
And did Mr. Bowman agree to that course of action?
She did, sir.
Now, did you indicate Mr. Bowman drove the car?
He did, sir.
Did he drive up the driveway to the store, or did he park somewhere else?
He didn't drive up the driveway, he parked somewhere else.
And then did you and Ms. Martinez walk up to the store?
He got Ms. Martinez off first, and then I dropped me off further down the road.
Okay. So you dropped, Mr. Bowman dropped off Ms. Martinez, like out on Chapel Dam Road, to walk up the driveway to the store?
Yes, sir.
And then he drove a short distance down the road and dropped you off?
Yes, sir.
And then Ms. Martinez walked up to the store, is that correct?
Yes, sir.
And what did you do?
I went to the woods, sir.
So you walked through the woods up to the store?
I did, sir.
Your Honor, I mean, Mr. Rowan's voice is a lot like Marilyn, and I'm only if you could be
All right. So when you walked through the woods, you say you walked up to the store, correct, sir?
I did, sir.
And did you go inside of the store building?
Yes, sir.
What happened inside the store building?
I realized I forgotten things, and I had a hammer, and I went to strike Ms. Robinette on the shoulder.
So you went to strike Mr. Robinette on the shoulder,
Yes, sir.
and you were using this hammer as a weapon to strike Mr. Robinette?
Yes, sir.
Did you wind up hitting Mr. Robinette somewhere other than his shoulder?
Of course, no.
And did you hit him on the head?
Yes, sir.
Now, your intention at the point in time when you struck Mr. Robinette, was it to disable him in some fashion so you then could rob the store and steal guns from the store?
It was kind of that, sir.
Okay. Did you, in fact, steal some guns from the store?
I did, sir.
And do you have any idea how many long guns you took?
I didn't take any practice, sir.
Do you have any idea how many handguns you took?
7 or 8.
And did these handguns belong to Mr. Robinette or to his store?
Yes, sir.
Did you have any permission to take those guns?
No, I did not.
And at the point in time that you took the guns, was it with the intention in your mind that you would take the guns somewhere else and sell them?
Yes, sir.
So the lawful owner of the guns never would have gotten them back, according to what you intended at the point in time you struck Mr. Robinette, and at the point in time when you took the guns out of the store.
Sir.
And was Miss Martinez also in the store at the point in time when you hit Mr. Dick Robinette?
Yes, sir.
Are you satisfied, Mr. Moore, that there is a sufficient factual basis for the defendant's guilty plea to count 2 armed robbery?
Your Honor, if I could defer to the prosecuting attorney before answering that question.
Sure. Mr. Miller, are you satisfied there's a sufficient factual basis for the defendant's guilty plea to count 2?
Your Honor, if I could just ask a few follow-up questions, I would appreciate the time.
Sure.
Mr. Rowan, you had testified to the judge just a few moments ago that you and Ms. Martinez and Mr. Bowman had met prior to this to plan the robbery, is that correct?
Yes, sir.
Where did you meet at?
Yes, sir. We met at my house.
Okay, and when did you meet?
About an hour before.
An hour before?
Yes, sir.
And who was present during that planning session?
Just Mr. Bowman and Ms. Martinez.
Okay, was he paying 100% attention to this planning, or was he doing something else while this was going on?
He was paying attention somewhat.
Was he participating in the conversation?
Yeah.
What, did he formulate any of this plan? Whose decision was it that he should be driving?
I wasn't driving.
Whose decision was it that Mr. Bowman should be driving?
It was mine.
And you told him where you were going,
Yes, sir.
and you told him what you were going to do?
Yes, sir.
And the plan was to go to the gun shop, and the plan was to take the guns, is that what you just said?
Yes, sir.
And Mr. Bowman knew this, correct?
Correct.
Okay, we're talking about Michael Bowman?
Yes, sir.
I have no further questions.
And Mr. Rowan, after you took the 7 or 8 handguns out to the car, did you, where Mr. Bowman was, did you get into the car with Mr. Bowman?
Yes.
And did Mr. Bowman drive you away from that location to somewhere else?
He is.
Later in the day, did you travel to the city of Saginaw?
Yes, sir.
And did you in fact sell the guns there or trade them?
Yes, sir.
Did Mr. Bowman drive you to that location in Saginaw?
He did not.
Are you satisfied, Mr. Moore, that there's a sufficient factual basis for the defendant's guilty plea to count 2 armed robbery?
Yes, Your Honor, the defense is satisfied.
And are you satisfied as well, Mr. Moore?
Yes, sir.
Very well, in this matter, the court has not agreed upon the possible plea or the possible sentence with the prosecutor or the defendant or anyone else acting in the interests of either. The court is convinced that the plea is accurate, has been understandingly, knowingly, and voluntarily made. The plea of guilty is accepted and ordered entered on the records of the court. Sentencing for the time being will be scheduled for Monday, October 14 at 1:40 p.m. Bond is canceled. The case is referred to the Platinum County Circuit Court Probation Department and the Department of Corrections for preparation of a pre-sentence investigation report. It's possible that sentencing might be adjourned to a later date. Anything further then?
Yes, Your Honor, I will state affirmatively that it is our position that the court is compliant with the court rules of the taking of this plea.
Thank you, sir. I had neglected to ask that. And do you agree, Mr. Miller, that the court has complied with the court rule?
Yes, sir.
Very well then. Once again, bond is canceled. I will see you, sir, on Monday, October 14, or on a later date. We'll be in recess.
All rise.